is the first case in the world that the judgment decided that the hour in the arbitration between AJT and AJU was set aside. Because under the rule of the municipal model law, Article 34 B2B2B2, so I'll explain the background of this case. The AJT and AJU were a business partners, so please shake your hands. When they're doing the business business calculation for the TB problem, but actually Stephanie was a bad person and she did a fraud. And she made a 3 criminals forgery and used a forged document. Now, if you have learned the criminal law in the country, you may understand the difference between those fraud and forgery and the use of forged documents, because forged is a criminal compoundable. And those two are non-compoundable criminals. So after Stephanie made those criminals, Jennifer told these crimes to the Thai police to investigate this issue. And while the prosecution was going, both of them went to the Singapore International Arbitration Court. And they made an agreement that the Stephanie pays $470,000 to Jennifer, and Jennifer gave the evidence of the termination of the prosecution and the termination of prosecution from Jennifer to Stephanie. And it seemed like they had an agreement under the arbitration court, but there is no happy ending. Why? Because AJT is Jennifer. Jennifer brought another brought a case to the criminal court in Singapore that the case go against the public policy, because as you remember, the evidence says the termination of evidence. The termination evidence of the termination is suspending the criminal prosecution of forgery and use of forged document. But those criminals are both non-compoundable, so it's not something what the Jennifer can promise to Stephanie. But the tribunal court say it is not going against the public policy. So Jennifer again brought a case to higher court in the Singapore, and the Singapore High Court decided that the case go against the public policy, which is underground of the one I told you before, Article 34 2b2, which is talking about the all hours in arbitration, which go against the public policy, should be set aside. So the case are set aside. And what is noteworthy is what the Justice Chen in the Singapore case talk about the scope of the public policy. So I just read his sentence. In an appropriate case, the court in exercising supervisory jurisdiction may examine the facts of the case and decide an issue of legality. While there is a need to uphold the public interest in issuing the finality of arbitration hours, the court has also safeguarded the countervailing public interest in ensuring that its process are not abused by the litigant. This is the end of So, if the SGHC didn't set aside their hour made in arbitration, I think the hour would be illegal formal agreement under the jurisdiction of the courts. So I support this judgment. So this is the end of my presentation. So I hope you had got some information or some interest from the case. So thank you for your attention.